Good morning, and thank you all for being here this morning. I'm going to go ahead and call to order this session of the City of Bremerton Hearing Examiner. For the record, today is March 24th, 2025 at 9 a.m. My name is Yoshi Kumara. I am a hearing examiner with Laminar Law, whom the city has selected to hold certain hearings like this one. Today on the agenda, we have 1 land use matter and 4 code enforcement matters. I believe it's the city's preference to begin with the land use matter. We can go ahead and get started. This is a request for a shoreline variance. For this request, it is my role to collect evidence in the form of exhibits and testimony to determine whether the proposal complies with the comprehensive plan, zoning ordinances, and the specific criteria for approval of a shoreline variance. For evidence in the form of exhibits, I have reviewed and will admit all exhibits I received prior to the hearing. If there are additional exhibits that anyone would like admitted, please let me know when you are testifying. And as a note, I may ask questions of those who are testifying to ensure that I have a clear understanding of the proposal, so that after the record closes, I'm able to produce a decision that is clear and legally defensible. I'm not trying to trip anyone up. I'm just really trying to understand the issue. For testimony presented today, typically the order we will follow will be the city will first provide an overview of the proposal, along with any recommendations, and then we will hear from the applicant or any representatives of the applicant. After that, members of the public will have an opportunity to testify. And finally, following public comment, we will turn back to the applicant and the city as necessary. All testimony today will be under oath or affirmation because were my decision to be appealed, the recording of today's hearing, along with the admitted exhibits and my written decision, would serve as the foundation for any such appeal. So turning to the matter at hand, the applicant, William Jett, has requested a shoreline variance to allow for a fence to be erected within the shoreline buffer on property located at 4635 Marine Drive Place. Prior to this hearing, I received and reviewed a number of exhibits. Those include the shoreline permit application and a narrative request for a variance, site plans and photographs of current conditions, a habitat management plan prepared by Ecological Land Services, various notice and publication materials, including comments from the Suquamish tribe and the Washington State Department of Ecology, as well as written public comments, responses to those comments prepared by the applicant, the staff report prepared by city staff, and the applicant responses to the staff report. And I will go ahead and admit these exhibits into the record today. Mr. Rowland, are you presenting on behalf of the city today?
I will be.
Great. Let's go ahead and get you sworn in. Please raise your right hand. Do you swear or affirm to tell the truth in the testimony that you give here today?
I do.
Thank you. And can you please spell your name for the audio recording and explain your role at the city?
Yes, my name is Justin Rowland, spelled Justin. Last name Rowland, Rowland. And I am a senior planner here at the City of Bremerton.
Great. Thank you, Mr. Rowland. And you may go ahead and present.
Right. So today's, the proposal is for a shoreline variance permit seeking to install a fence within the shoreline buffer area, which is regulated per BSMP 7.010 B7. To assist with the description, I will do a quick screen share. Where you can see the site plan, which is provided within Exhibit D. So as not to intrude into environmentally sensitive areas, fencing is only permitted in the outer half of the shoreline buffer consistent with BSMP 7.010 B7 and is only permitted on side property lines. The shoreline buffer is illustrated on the site plan with a blue dashed line, with the applicant proposing fencing appearing in red, which entirely encloses the buffer area. The proposal violates the code by appearing on the waterward half of the shoreline buffer and by not being limited to side property lines. Public notice was provided per project permit sections BMC 20.02 5.2, and B, SMP 5.030 as a Type 3 shoreline permit. Public comment was received and considered by staff. All interested parties were invited to attend this hearing, as well as neighbors within 300 feet of the property. No additional comments were received during the notice of hearing comment period. Per BSMP 5.040C1, the city may grant a variance only if it is found that all 10 criteria in 173, 27, 170 of the Washington Administrative Code are met. As detailed in the submitted staff report, the application only meets 2 of the 10 criteria required for approval. After the city makes a final decision, the permit and the application are required to be reviewed and approved by the Washington State Department of Ecology. Based on comments received, Ecology would not support the approval of this variance application, as the proposal does not conform to all 10 criteria of approval, and based on the absence of support from Ecology at this time, the city recommends denial of the permit. Are there any questions for me?
Thank you, Mr. Rowland. I do have a few questions. So the first question I have is, it does seem like many of the properties in this area don't conform to current regulations. And I'm wondering if you have any information on sort of whether those are, I assume many of them are legally non-conforming, but I'm just wondering if you had any comment on how that would occur or any specific information about those surrounding properties.
I don't have any specific information about the surrounding properties, but many times if there are conditions that are currently non-conforming, it would either be that those properties were established before our current code, as that's the only way to legally have those non-conforming conditions.
And do you know if there are any properties around there that have gone through a similar shoreline variance process?
I am not aware of any properties in the vicinity that have gone through a shoreline variance process. At least within the 5 years that I've been with the city, we have not had any shoreline variances in the city.
Great. Thank you, Mr. Rowland. In your staff report, you mentioned that the proposal is not the minimum necessary for relief because the property owner can install a fence. And I just wanted to make sure that I understand sort of how the Shoreline Master Program fence provisions would apply in this case for this property. And so under Chapter 7, Section 7, it allows a fence to be placed in the outer half of the buffer, as long as it has the wildlife passable gaps or the reductions. So does this mean that the fence, I think there's a 100-foot shoreline buffer, so this means there could be a fence 50 feet from the shoreline. Is my understanding of that correct?
So with our code, yes, it would be the fence would have to be set back at least 50 feet from the ordinary high water mark if there's a 100-foot buffer, and that fence would have to be within the side yard of the properties. It could not cut across the buffer, as to put it. So any fence that would cut across the buffer or that would cut across the property would have to be set back to the shoreline buffer line. So in this case, based off of the site plan provided, it would have to be set to the blue line with fencing that would be allowed in the side yards, set back at least half of the 64-foot buffer, which would be 32 feet back from the ordinary high water mark.
Okay, and that would be for the side yards.
Correct.
Okay, thank you. I appreciate that. That helps clear that up for me. My next question is about the in your staff report, you note that that a hardship is one of the criteria. A hardship is specifically related to the property, and you mentioned that safety and security are not considered unique conditions under that provision. Can you explain a little bit more about what the unique conditions provision allows for, or why these don't qualify?
Yeah, so unique conditions relate specifically to the site. Typically, this relates to things such as topography, site shape, and size, which would either significantly prohibit the development and use of the site, or it would outright prohibit it based on certain code aspects. Safety and security are more general concerns. One person, or I guess I'll just leave it at that.
Great, thank you. I don't have any further questions for the city at this point. Are there other people on behalf of the city wishing to provide testimony this morning? No. Okay. And so with that, I think we can turn, if there's no one else wishing to provide testimony on behalf of the city, I think we can turn to the applicant. Good morning.
There we go. Good morning, Your Honor.
Good morning.
My name's Ken Bagwell. I'm here as attorney on behalf of William Jett this morning. I'm sorry, I just received notice from my office that my notice of appearance did not go through the system, so I'm here as a surprise to you, and I apologize for that.
Great, thank you this morning. Ken, can you go ahead and spell your name for me?
You bet.
So
It's Kenbagwell.
Great, and you're here on behalf of the applicant. Are you hoping that the applicant will be able to testify, or are you going to direct questions to the applicant?
No, my client is here and is more than willing to testify. I think, as you've seen from the materials that have been submitted by him, he has put a lot of effort into this request. It's very important to him, and we've had many conversations about this process with him. And I think there's a few things that I just wanted to point out, and then I'd be happy to turn the time over to him. And then you're more than welcome to ask him any questions that he may have.
Great. Thank you, Mr. Bagwell. Why don't you go ahead and get started, and then we can move forward from there.
Your Honor, I've been doing this for quite a while. In fact, I used to work for the city of Bremerton in the city attorney's office. The first thing I wanted to point out is that I was surprised, and I understand the city's busy, and this seems to be a pretty small development request, considering it's just for a, less than a 4-foot fence through the shoreline buffer. But I'm concerned that the staff report was, in essence, devoid of any authority supporting its conclusions. Certainly, it referenced the necessary WAC and the Bremerton Municipal Code. But as to the city's conclusions regarding a failure to meet the standards outlined in the WAC, they appear to just be conclusory. There really is no authority for stating that some of the conditions in the WAC were not met. And I think that's important for a couple of reasons. First and foremost, I'm sure that you've had an opportunity to look at the Department of Ecology's handbook, I guess, that they have on issuing variances to the Shoreline Management Plan. I'm sorry, I'm kind of juggling up here. There's not a lot of room here on the dais, but it's the most recent version of the Variance Permit Reviews Guide for Local Governments. It was issued in June of 2023. And there's some really important information in that as it relates to Mr. Jett's request. But first and foremost, at the very beginning, it talks about the fact that any local government, in considering variances, require deliberate and professional judgment. We recognize the onus is on Mr. Jett to show that he can comply with the conditions in the WAC, but there has to be some demonstration of consistency within the staff report to rely on. Staff reports need to include independent findings and conclusions, and they should provide a clear, defensible analysis of how a proposal can meet or does meet with conditions of approval, or it does not meet the criteria. And just by the city saying that the proposal does not meet the criteria without considering the specifics of Mr. Jett's requests are concerning, from the perspective that if we move forward and need to appeal, all of the evidence supporting this request has basically come from Mr. Jett, including the habitat management plan, the specific requests that he has related to the use of his property. In moving forward, I just want to point out a few of the concerns that I think should be considered in this process. Mr. Rowland pointed out that of the 10 conditions set forth in the, sorry, I'm juggling my paper here again, so I'm trying not to lose my spot. Of the 10 conditions set out in the WAC, Mr. Jett could only meet 2 of those, and those 2 really didn't apply. The first was that the variance permit should be granted in circumstances where denial of the permit would result in a thwarting of the policy enumerated in RCW 9058.020. And that, of course, is outlined in the staff report that it is the policy the state provide for the management of shorelines, et cetera, et cetera. The policy designed to ensure the development of these shorelines in a manner which, while allowing for limited reduction of rights in the public in navigable waters, will promote and enhance the public interest. And it does contemplate protecting against adverse effects to the public health, the land, its vegetation and wildlife, the waters of the state, and their aquatic life, while generally protecting public rights and navigation. All of those issues set forth in that policy statement have been resolved by the habitat management plan. We, in essence, have no adverse ecological impacts by this proposal. The expert that Mr. Jett hired laid that out very clearly in her report. And so in considering that, this request seems to be a very reasonable use within that shoreline buffer. We do recognize that there is state interest over local interest, but in this case, the small fence across the property for safety seems to be a very reasonable use, considering that the law does acknowledge that fences are appurtenant to a home and a reasonable use. We're just talking about in the buffer, of course. The second criteria, that the strict application of the bulk, dimensional, or performance standards set forth in the applicable master program precludes or significantly interferes with the reasonable use of the property. I think Mr. Jett has made it very clear in his information submitted how the denial of this would impact what is a very reasonable use of his property. It is interesting to note that in the staff report that the city says in place of a fence, a safety rail may be installed at the top of the bulkhead to address life safety concerns. And I guess I'm curious as to what the difference between that safety rail may be and a small fence set back off of the bulkhead a little bit. We all know that there would be code requirements for a safety rail, and frankly, the safety rail may be more of a impact than just a small, short chain link fence. The third criteria, the hardship described, is specifically related to the property and as a result of unique conditions such as irregular lot shape, size, or natural features. I would point out that that's not an exclusive list. I mean, the law makes it very clear that the property location in and of itself may be a consideration. And in this particular point, case, the property location is the problem. Unfortunately, what Mr. Jett has observed due to the location of his property over time is that there are more and more individuals walking the beaches willing to come up onto his property, and there appears to be definitely more stray animals that have been accessing his property. And that is simply due to the location of where his property is at. Another criteria, the design of the project is compatible with other authorized uses within the area and with uses planned for the area under the comprehensive plan. I know the city will say, well, fences are never authorized within the buffer, so this doesn't meet the with the planned developments in the future. The problem is that there are many fences in this area and other developments that are outside of what the law would now allow. And it's important to consider that other people, individuals, whether they've gone through the appropriate process or not, have built fences. That's not Mr. Jett's concern. Mr. Jett is just trying to follow the appropriate process to do this legally. That the variance will not constitute a grant of special privilege not enjoyed by other properties in the area. I know there's some concern that if Mr. Jett's variance were granted, that he would be different. In this particular case, we've seen the letters from the neighbors. They're pretty clear that they don't want a fence in their neighborhood. So we're not too worried about that, not including the fact that the process through the city of Bremerton is pretty onerous and costly. Is it the minimum necessary to afford relief? Well, the city relies on the fact that it is not, because they can build the fence within that down to the buffer, but as you saw from the blue line, basically runs into his house. Anywhere else out through that buffer, he's got a drain field and just doesn't allow for what he is trying to accomplish. That the public interest will suffer no substantial detrimental effect. Again, I think we look to the habitat management plan. It's really clear there is no ecological impact here. Sight lines are not affected. There really is no concern for that. Let's see. In the granting of all variance permits, consideration shall be given to the cumulative impact of additional requests. Again, we're not too worried about this. The Department of Ecology points out in its variance handbook that if there are no ecological impacts, we're not worried about cumulative effects. And in this particular case, again, it's been pointed out there are none. And again, the opposition from the neighbors, I think, shows that we're not too worried about the cumulative impacts. So I think I'm going to wrap up and just point out that I think while the city has concluded that these 8 conditions can't be met, again, there's no authority or support for them. And the evidence that my client has submitted overwhelmingly supports the idea that he should be allowed to have this short fence crossing the buffer on his property. And with that, I'll let Mr. Jett come up and speak to the proposal and answer any of the questions you may have.
Great. Thank you, Mr. Bagwell.
Thank you, Your
Good morning,
Honor.
Jett.
Hi.
Hi. We'll go ahead and get you sworn in. So if you can raise your right hand. And do you swear or affirm that you will tell the truth in the testimony that you give here today?
Yes, I do.
Great. Thank you. Can you please state and spell your name for the audio recording?
Yes, it's William, William, Jett, Jett.
Great. Thank you, Mr. Jett. So now it's your opportunity to provide information about the proposal as well as any additional information you would like me to know.
Okay, thank you. Well, Mr. Bagwell did a good job of summarizing my response and comments to the 10 points or the criteria that the city had in their staff report. And I'll kind of summarize again the need for that. And there is a dog problem. We've been attacked, my family and my pets, on a number of occasions for many years. The fence is the solution. Other solutions proposed by the city, the Department of Ecology, were such like a heavy vegetation blockage or hedge or something of that nature. And that's really not a solution at all. For one point, it would take years, maybe decades, for a hedge to grow in so thick that a dog couldn't just push right through it. So I don't have that much time to wait. I have a limited horizon, and I'm trying to get this done before I pass the property on to my heirs to deal with this issue. The Habitat Management Plan and the two other biology reports that were also submitted, I hope you have those, all state, as Ken summarized, that there is no impact. I have a seawall that separates me from the shoreline. Even in the staff report, it says it's a grassy yard, a residential front yard, like it was pulled out of downtown Bremerton. I have no natural habitat or vegetation on the property. And as a result, I don't believe that there's a buffer zone that is required. Buffer zones are to protect habitat. There's no habitat that needs protection. And that's why I'm asking for elimination of the buffer zone so I can fence all the way up to the bulkhead and enclose my yard. We're fearful of using our front yard, even sitting out on the patio. We come out with a stick and a taser. My wife, or my ex-wife, and my daughter who live with me don't want to use the front yard. This is our main area of recreation. It's where the view is. It's a place where we could play croquet or entertain people, but I don't feel that the safety factor is there that I would want people there. We've been charged a number of times. I mean, the dogs have charged us. They've attacked my dogs. Even multiple dogs ganging up on my dog. I kept my dog on a line, but I'd really like to be able to allow him to run free in the front yard, and I'd like to use the front yard as well. So that's the hardship. The city has a pretty restrictive definition of hardship, and they're tying it to the property, but if you read the statute itself, it says such as. It doesn't say limited to. So it just gives examples, and there are many other types of hardships that someone can endure. So that's my hardship. I'm not able to use my property to its fullest. I'm paying property taxes on property that I can't enjoy. And so that's kind of wanted to summarize the need and why I'm going to this really tremendous expense and trouble to protect myself and to protect our ability to recreate on our own property. If there's any questions I could answer, I kind of
Great. Thank you, Mr. Jett. I do have one question either for you or Mr. Bagwell. As the city mentioned, even if I approve the variance here, Department of Ecology has the final review and approval decision in this instance. And so I just wanted to get your sort of, I think the city, when Mr. Rowland was testifying, he noted that drove some of their decision. And so I just wanted to get your take on sort of that, and at least your understanding that even if I were to approve this variance, that the Department of Ecology would have the final say.
Oh, sure, I understand that, and that was written into the report. I hope that they could come up with something more that they've come up with so far, because I have submitted what I think is a logical rebuttal, and most of their argument is still hanging on the fact that there is a habitat there that's being impacted, and that the Shoreline Management Plan and the WAC and the Revised Code of Washington statutes apply to something where there really is no habitat and there is no impact. So they've that, and the Department of Ecology and the city have based their premises on, well, I think they've just ignored or disregarded the Habitat Management Plan and the reports from the two biologists in that regard. And so maybe they would reread the Habitat Management Plan and reconsider their findings. A couple of their points were something to do with if a coyote could jump the fence, a dog could jump the fence. Well, that's not a reasonable argument against not having a fence. Some dogs could jump a fence. I had a dog that could jump a 6-foot gate. and preferred jumping the gate rather than jumping the 4-foot fence. So, but it will keep out many animals, many dogs, and is a deterrent to people. Excuse me. And again, has no impact. Another consideration that they put was a cumulative impact that this might create, and it sets a dangerous precedent that it might create an upswelling of requests for people wanting to seek a variance. And I don't think that's a good argument either. Because mine is such a one-off case, no other property around the point has the height of bulkhead that I have, therefore creating a safety hazard, as an example. They all have front lawns that look just like mine, except they're probably better well kept than I keep mine. But nevertheless, I don't think an upswelling or some fear factor that there's going to be a rash of variance requests come flooding in is a logical argument at all. So anyway, I do realize it goes to the Department of Ecology. I hope they can come up with some reasonable arguments if they choose to deny something that maybe someone else has approved, like yourself, ma'am.
Great. Thank you, Mr. Jett. And is there anything else that you or Mr. Bagwell would like to add before I turn to, I'm not sure if there's public comment, but before I turn to the next portion?
I'm just want to be sure that you did also receive the 2 reports from the biologists. They were field studies, not full habitat management plans.
Does the habitat management plan incorporate those? I don't think I've seen those, but often the habitat management plan will incorporate those. If you would like to send those along, you're welcome to.
Well, they restate, but I had a separate biologist do a field study. Same thing. There was no impact. There were no sensitive areas on the property. Otherwise, the habitat management plan was written by the same biologist that she presented a field study ahead of that. So it's probably not additional information, but it just reaffirms that there was no impact to my proposal.
Great, thank you. You're welcome. If you would like to, you're welcome to submit that. But I do think that it's largely incorporated. If it's largely incorporated into the habitat management plan, then I have that information.
Okay, thank you.
Great, thank you both.
Thanks.
Is there anyone from the public, either in person or online, wishing to testify about this?
Yoshi, there's somebody in person. Yeah.
Oh, okay, perfect. If we can have that person come up, thank you. Good morning.
Good morning.
If you can go ahead and raise your right hand, get you sworn in. Do you swear or affirm to tell the truth in the testimony that you give here today?
I do.
Great, thank you. And if you can state and spell your name for the record, that would be great.
It's Mike Dubos, Micheldubos.
Great. Thank you, Mr. Dubos. And go ahead and provide your testimony.
Hi, would be Mr. Jett's neighbor to the north, and I wanted to just echo some of the statements that Mr. Bagwell, I agree with him on some of his. I also agree with Mr. Jett on some of his. There's definitely been some dog issues in the past. I guess my take would be that both dogs, someday, both of us will be gone. My biggest objection from day one with regard to precedent fence-wise, I think it would cause a tremendous negative precedent across the board. Once something is set, I think there'll be numerous requests for fences down the road. We all pay, as Mr. Jett said, a tremendous amount in taxes, especially on the water. And originally it was going to be, I think, a 6-foot fence, which if I'm standing in my kitchen looking out, I'm staring at a 6-foot cedar fence, which was not by any means going to be a pleasant view. And of course, that's when I thought, hey, I think something's going on here that probably shouldn't be. So obviously there was a conversation had, and we're here today. So that was really my onus of saying, hey, we need to kind of figure out what's going on here. So that's been my kind of hard stop point where I don't really like where this is going. So myself, several of my neighbors are like, we're all kind of in that same position saying this is something that we're not really crazy about. Now, that's not our position to say, hey, we don't like it. We're going through this process, and really that's the only thing that I have to object to and go through the process of whatever needs to happen, but we want it to be done per, whatever the state says is or isn't allowable. And that's really all I have to say.
Great, thank you. Is there anyone else wishing to testify? No. Okay, great. Thanks, Ms. Schwartz. With that, I'll turn back to the city. Mr. Rowland, if you have any comments or further information.
I do see our city attorney, Jett, show his camera, so I'd like to turn it on over to him.
Great. Good morning, Mr. Jett.
Good morning.
Looks like you might have some comments.
It is actually Jetty.
Jetty, thank you.
Yeah, I just wanted to provide a couple of legal comments. One regarding the consideration of cumulative impacts. I think there's been a lot of talk about that from Mr. Jett and the individual who just testified. I think the key here is that there has been nothing submitted regarding cumulative impacts other than we don't think it'll happen. We're not really concerned about it. That's not the standard in the WAC. The cumulative impacts need to be given consideration. The city noted in its staff report that there was nothing regarding cumulative impacts. In the written response, Mr. Jett essentially says if the city wanted that, they could go get it themselves, but he in fact bears the burden on that. And I think saying that it's not a concern, it's an expensive process to do this, there probably won't be, isn't enough for the cumulative impacts. And then the other part that I wanted to just really touch on was basically the a special privilege if this is granted. There may be other properties that have been grandfathered in for various reasons, but giving Mr. Jett a variance here would in fact be a special privilege that has not been given to anybody else, and it would be inappropriate to give him a special privilege. So I think those were really the two things that I think I just actually heard comments on and just wanted to respond to. So thanks.
Thanks, Mr. Jetty. Mr. Rowland, anything else?
I don't believe I do have anything else at this time.
Okay. Yeah, it does look like great. Go ahead. Sorry.
Are there any other questions that you may have for me on any of the items that were touched on?
Thank you. I don't have any other questions. It does look like Mr. Bagwell was about to stand up, so I will turn back to him and we'll keep this brief. We won't keep going back and forth for too long, but go ahead and provide additional comments, Mr. Bagwell.
Thank you, Your Honor. I wanted to point out regarding the cumulative impacts, reiterate what I had stated earlier. Because the habitat management plan that was submitted by my client indicates no ecological impacts, and this is coming straight from the Department of Ecology's Handbook on Variances, stating that if a project avoids impacts to shoreline ecological functions, it will not contribute to a cumulative impact on ecological functions. So in essence, my client's determination was that, listen, I've got this habitat management plan saying it doesn't affect the ecological condition on the site, and so we don't need to consider other cumulative impacts. And whether there's other cumulative impacts on other policy objectives of the Shoreline Management Act, access to public access, there is no cumulative impact. Recreation, public navigation, or water-dependent users, this is private property. And so from our perspective, if someone sought a variance for a fence on their property and could show no ecological impact, that's not a cumulative effect. Thank you.
Thank you.
And I'm sorry, I think Mr. Jett had one thing to add regarding the special privilege argument.
Great, thank you.
Thank you very much. Yeah, I would like to object to that term special privilege. It's as if I'm receiving something that nobody else has the opportunity to apply for. They all can apply for the same variance if they wish to. If their specific circumstances, their property, and whatever else the circumstances might be, would probably not get them very far. So there's no special privilege here. I'm asking for the same privilege of safety on my property, the ability to use my property that anyone else would ask for. And it's a reasonable request, not special privilege at all. That's all I wanted to say about that.
Thank you, Mr. Jett. Mr. Rowland, Mr. Jetty, if either of you have any final comments, but otherwise, Mr. Jetty.
I have no comment.
Okay. Great.
I have no further comments either.
Great. Then I think we'll wrap this up. Thank you, everyone, so much for being here today. I appreciate everyone's time. I am going to go ahead and adjourn this first matter, and I intend to issue my decision within 10 business days.